All right, ma'am, are you Destiny Williams?
Yes, ma'am, I am.
Will your client waive the formal reading of the motion in each case?
She will in each case, Your Honor.
And Judge, just a little bit of procedural history, because it took Mr. Burbank and I a second to figure it out. Irrespective of the fact that the motion itself and the language does not state she was extended a year, then 3, then 4, she was. Well, I went back and looked at her original record, so I believe that at the time this motion was filed in September of 22, it would have told that probation that was set to expire, but the motion doesn't read that way because it doesn't have the 1 in there. I can do
Okay.
an oral motion to amend that 1-year extension.
No, that's okay, as long as you guys both agree and it appears that
Extensions in total to make that 2012 case run to 22, and this motion was filed so prior to it discharging.
Okay, all right, and you agree with that as well, Mr. Burbank?
I don't want to, Judge, but
But you do agree to that as well?
yes, information they had and I didn't. And
Okay, all right. So we all agree that there was a 1-year and then a 3-year and then a 4-year extension in cause number 12-14477.
Correct.
Okay, and probation's here as well, and is that your understanding? Thank you, and thank you for your patience this morning. Okay, so will she waive the formal reading of the motion in each of the cases? If I didn't know. Ms. Williams, in cause number 12-1477, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation November 5th of 2012 for the offense of robbery, and that was initially a 3-year probation deferred that was extended several times. Is that correct?
Correct.
And then in cause number 19-32216, I also have a motion to revoke your unadjudicated probation. This shows that you were placed on probation September 25th of 2019 for the offense of illegal transfer of EBT benefits, and that was a 5-year probation deferred that was extended at least 2 times. Is that correct?
It was extended once from my understanding.
It looks like it was extended for 3 years, December 2nd of 2016, and then another 4 years.
Was she put on 19?
I didn't get the illegal
19.
food stamps.
Oh, 19, so it wouldn't,
17.
yeah, you're right. Okay, so it was extended 1 time.
Yeah.
Okay. I'm gonna mark that out.
So we'll just
Abandon that.
strike that 3-year extension, if you would, Judge.
Okay, so it was extended 4 years from the original date, correct? Just 1 extension in that case.
To my knowledge, I completed this. With me going on the run again, it was counted like I didn't complete it. I paid my stipulations and
Well, that's how it works, is there was a motion to revoke filed before it was over, and so that tolls it, so you didn't complete it if you went on the run, right? Completing it means you successfully complete probation, doesn't just mean the time passes.
well, just the food stamps. I signed paperwork saying that I completed that part of it. And I was off my case for a whole year. From my understanding is what my probation officer had me sign. But yes.
So probation's here. Ma'am, if you'll just please state your name for the record.
Alexandra Robinson.
And Ms. Robinson, do you have the file in 19-32216?
I did have it in my file folder over there.
Would you just double check in that real quick and make sure that there wasn't something, do you have any personal knowledge, or do you need to look at it to see if there was something
I
signed?
need to look at it because I took on her case in August of 2024. I have not seen her in the office. So a lot of these things would be from her previous offices.
Well,
But I can't look in the file.
I'm looking back. It would be in my file as well if there was a dismissal of the motion. I mean, if the case was satisfactorily completed. So, no, you got on probation September 19th of 2019. There was an order of deferred adjudication. There was an administrative hearing in August of 2022. A motion to revoke filed in 2022. And here we are because you've been gone. So your probation obviously wasn't over. Okay, we're good. Okay. And is there no agreement? There's not an agreement?
No
If-
agreement other than.
If there's no agreement, we're gonna go through the whole motion. Yeah. I want I want everything, in front of me that I need. All right, so, Ms. Williams, in each case, Count 1 alleges that you failed to report to the Jefferson County Probation Department as ordered March 10th, April 29th, and May 31st of 2022, and is that true or not true?
True.
Count 2 in each case alleges that you failed to report for a judicial review August 22nd of 2022. Is that true or not true? Count 3 alleges that you failed to work faithfully at suitable employment and provide verification of that to probation. Is that true or not true?
That's half true. She wasn't reporting, so she couldn't report that she was working, but she had employment, which would probably come.
And provide verification of it.
That's right.
So did you provide verification of it? Of working? If you weren't going to probation, then I'm assuming you did not.
Right.
Okay, so is that true or not true?
True.
Count 4 alleges that you failed to immediately report to the probation officer your change of address. Is that true or not true?
Is that not true?
It's not true.
That's not true?
That's not true.
Okay. Count 5 alleges, count 5 in cause number 19-32216 alleges that you failed to provide verification of performing your community service hours as ordered. Is that true or not true?
Did you do all your community service hours?
No, I didn't do all of them. I was pregnant like almost every.
It's true or not true? Did you fail to provide verification? This is in the illegal transfer of EBT benefit case.
What about it?
It alleges that you did not provide verification of performing the community service hours as required. Is that true
I
or
didn't
not
complete
true?
all of my community service, but I was doing.
Is it true or not true?
It's not true.
Okay. Count 6 in that case, in the 2019 case, alleges that you're behind in your court-assessed fees as of August 22nd of 2022 in the amount of $2,956. Is that true or not true?
It's true.
And then in cause number 12-14477, count 5 alleges that you failed to pay your court-assessed fees as directed, and that as of August 22nd, 2022, you were behind $3,353. Is that true or not true?
It's true.
And count 6 in that case alleges that you failed to successfully complete the Impulse Control Education Program. Is that true or not true?
I didn't know I had a drug.
That's true, you didn't do it.
It's an Impulse Control Education Program.
It's anger management.
I don't know what it is. Did you do it?
No,
Okay, so it's true.
it's true.
Okay. Did you enter your pleas of true in each of the cases to counts 1, 2, 3, and then in the 12 case, 5 and 6, and in the 19 case, 6, freely and voluntarily? And did you plead true to those counts because they're actually true? Okay. In each of the cases, I have some documents here on the tablet that have your signature on them. Did you go over those with Mr. Burbank?
Yes.
And do you fully understand them?
Yes.
And there's no agreement.
No.
So,
You're gonna have to modify the paperwork in reference to the counts. Or do you have to?
yeah, well, yeah. I don't really know that. Okay.
We alleged counts 1 and 3.
Y'all filled out an agreed punishment recommendation paperwork instead of unagreed. So that's an issue because it's not agreed. And so if it's not agreed, there are some rights to appeal, and you've also signed the post-conviction waivers. So,
Well, we agreed on the 1 and 3, that's probably the reason why we did it. I did.
but if you're leaving it up to me, I want to know how she's done on probation.
Well, I thought you would get that in reference to the PSI report.
But I want to know if she takes responsibility or not. I mean, I need to know all those things. So, okay. I'm going to mark through the post-conviction waivers because it's unagreed. I'm just going to write unagreed here, so we don't have to do it over. And I'm going to write it's not a plea bargain there. State tenders number 1 in each case. Did I already do that?
No objection, statesman.
It's admitted in each case. Any evidence that Ms. Williams is not competent?
No, yeah.
All right. I'm going to find that you entered your pleas of true to the counts you pled true to in each case freely and voluntarily. Find those counts true in each case. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your case so that the probation department can do an updated report. That'll give me more information about you and your cases, and then we will come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Burbank, and he will present it to me on your behalf when we come back.
One thing, Your Honor, it is deferred. I would ask that a bond be set. I know that she has not reported. She was working full-time.
She just admitted in front of me that she's been on the run, and so I think based on that, based on the nature of the fact that she's been extended, we have a case from 12 and 19, and that there's not even the possibility in the 12 case for anything other than a revocation because of the dates, that I'm going to deny that request. All right, you can go back with the bailiff. Right. Perfect. So Ms. Pugh, Mr. Jeffries has been appointed to represent you. He's just been given, he's trying to get caught up real quickly on all the information and the discovery in your case. I'm going to reset your case so that he can get all of that. Once he gets it, he'll be out there to go over it with you, and we'll see if we can get an announcement at the next court date.
Respectfully, Your Honor, I do not agree to comply with any of the appointed court agents, considering that their first duty is to the state.
I understand. We've had this conversation before.
Conflict of interest, and for the record, I'll be representing myself.
So if you want to represent yourself, there's some things. Ms. Pugh, stop talking over me. If you want to stop talking over me. If you want to represent yourself, then there is a process that we have to go through, and we'll do that today. If that's what you want to do, we'll get your case set for trial and we'll go forward that way. It is highly inadvisable for you to represent yourself. Lawyers have many, many years of training. They understand the law. They understand how a trial works, because here's what happens. When you're in a trial and you represent yourself, you're expected to know and follow all of the rules of evidence, all the rules of procedure. And so you're really at a disadvantage if you don't know those things. And so you have to do everything just like the assistant district attorney would. And if you don't, you're going to be in front of a jury and it's going to show, and it's just not going to be, it usually does not work out in your benefit. But I have to go through with you some questions first before we do that. And then if you still want to do that, then there's a couple of options, and we'll go over those as well, okay? So I am supposed to ask you, I'm going to go through these questions. I need you to answer them if you want to represent yourself, because this is required, all right? So have you ever studied the law? Okay. Have you ever represented yourself before in any kind of criminal matter? Okay. Do you understand the charges against you?
I know we've been accused of.
Okay. And so do you know, and we've gone over before, I think, what the range of punishment is if you're found guilty on a jury? Do you know what that is? Let's see. Hold on a second. Let me pull you up here. We'll go over that again as well. The date of that allegations from June 22nd of 2021. And what that means is if you're found guilty, that the range of punishment that the jury could give you is between 2 years as a minimum punishment up to 10 years in prison, anywhere in between. Do you understand? And you answer out loud just for the record.
Do I understand? No, I don't understand.
What do you not understand about that?
I don't understand, Your Honor.
So here's the thing. If you want to represent yourself, by law, you have to be able to understand these things. Otherwise, I've got to appoint an attorney for you. So you can't just say, I want to represent myself because I don't like the attorney or I don't like the process. This is the process that you're in. You live in Texas, you live in the United States. This is the law that applies to your case. So what do you not understand about the range of punishment if you're found guilty? And I'd be glad to explain it.
I don't understand because I'm gonna be anything wrong.
That's what a jury's for, right? And so if you say you're not guilty, then you go in front of a jury and they determine after they listen to the evidence if you're guilty or not. That doesn't have anything to do with if they find you guilty, you understanding that they could send you to prison for between 2 years and up to 10 years. Do you understand that part? What are you, yes or no? No, you don't understand that. So, Ms. Pugh, it's my understanding, I'm not going to allow you to represent yourself because you don't understand the law and the process. So we're on question number 4 out of 15 that I'm supposed to ask you. So Mr. Jeffries is going to stay on your case.
I don't know when Mr. Jeffries on my.
I don't care what you want at this point. You can't do it. All right, you can go back with the bailiff. I'm done. Go back with the bailiff.
It's not on my case.
Go back with the bailiff.
It's not on my case.
Welcome to the criminal appointment list.
Yeah, fun, Judge.
This was not meant to be any kind of punishment, I promise. So Mr. Jeffries, just, get ready like you would. Probably it's going to go straight onto a jury.
Right, I would
And
assume.
we'll just get it figured out that way. All right.
Thank you, Judge.